before making any substantive submissions, I must record my delegation's profound concern over the unfortunate situation. We noticed that the judge ad hoc nominated by Pakistan could not attend the proceedings yesterday, and he is not present today. This is a matter of great concern for Pakistan. Pakistan exercised its right to appoint a judge ad hoc, as provided in Article 31(2) of the Statute of International Court of Justice. Article 32 clearly provides that if one state party to a dispute has a permanent judge on the bench, the other state has the right to appoint a judge ad hoc. This fundamental procedural right of the state party to a dispute, a right that Pakistan exercised in good faith and in full compliance of the rules of the court. Regrettably, however, this right is yet to be effectively exercised. The judge ad hoc has not yet been sworn in. Accordingly, at present, Pakistan does not have a judge ad hoc. We have further been informed that the judge ad hoc, Mr. Jilani, is indisposed and is unable to attend the proceedings. We wish Mr. Jilani a quick recovery and that he restores to good health. Pakistan is ready and committed to presenting his case to the court, but we invite the members of the court to appreciate the extraordinary situation that we find ourselves in. If proceedings continue, the vital part of the proceedings shall conclude today, and Pakistan's procedural right to have a judge ad hoc on the bench shall stand permanently frustrated. While a citizen of the complaining state sits as a permanent judge on the bench, the responding state's right to have an ad hoc judge is not effected. In light of the above, Pakistan, while placing itself in the hands of this court, is obliged to request the court to allow for another individual to be sworn in as provided for under Article 35(5) of the rules of the court. Article 35(5) provides, and I quote, "A judge ad hoc who has accepted appointment but who becomes unable to sit may be replaced." This rule caters to precisely the present situation. It is also requested that the court may give him sufficient time to go through the brief. I would like to reiterate that Pakistan is ready and committed to present its case to the court. As always, we remain assured that the interests of responding states will be adequately guarded by this court, and Pakistan requests will be met with consideration and circumstances as the circumstances demand. I am in your lordship's hands. That is all. As this court so pleases.
Have you completed your introduction of today's hearings, the presentation of Pakistan?
Yes, we have completed the presentation of Pakistan. My statement is ready. That is also there, but for this, I am in the court's hands.
I would like to ask you to read your statement. I would like to ask you to read your statement.
Okay.
If your statement is ready.
It is ready.
And we are ready to hear you and to hear your side. And the arguments of Pakistan.
I will proceed, sir.
Thank you.
Your Excellency, the President of the Court, Honorable Judges, Excellencies, ladies and gentlemen. I, the Attorney General for Pakistan, am honored before this august court as the agent of the Islamic Republic of Pakistan. With the leave of the court, I would like to introduce our delegation. Dr. Mohammad Faisal, the co-agent for Pakistan. Mr. Shujaat Ali Rathore, Ambassador for Pakistan to Netherlands. Mr. Ahmad Irfan Aslam, Mr. Taimas Rizvi, Mr. Khawar Qureshi QC, Legal Counsel and Advocate, Mr. Joseph Tyke, Legal Assistant, Ms. Katrina Nicol, Junior Counsel for Pakistan, Mia Shaur Ahmad. Mr. President, Honorable Judges of the Court, I would provide a brief overview of the form that Pakistan's submission will take. This esteemed court has been made aware from the pleadings of the parties here, giving the background, events leading to the appearance today. However, I need to talk straight, seeking to highlight the heart of the matter, with a view to emphasize the inconsistencies and contradictions made with the aim to mislead this honorable court. The Constitution of the Islamic Republic of Pakistan provides for due process as a fundamental right, tolerance, and being peaceful. All laws are made by the Parliament in accordance with the Constitution after proper debate and discussions. The local laws are thus within the domain of the Parliament and the independent courts of Pakistan. Similarly, the creation of military courts was through this parliamentary process. Pakistan's sovereignty cannot be compromised under any legal dispensation. All courts are working under due legal process, having proper jurisdiction as provided by law. In contrast, without due process, the action of our neighbor, India, chooses to destabilize and create hegemony over its neighbors by force, causing terrorism, training terrorists for acting in neighbor countries, sending their trained spies to fund, create chaos in those countries. For our part, we wish that were not so. Moreover, we wish to make it absolutely clear that we remain committed to the path of peaceful resolution of all outstanding disputes. Pakistan, as a consequence of the Indian intervention, along with others, is a major victim of terrorism, where the country and its innocent citizens continue to fight this menace both inside and on the borders. Pakistan has continuously suffered more than 74,000 casualties and fatalities due to terrorism caused mainly by the interference of our neighbor, India. It is in this context that Commander Kulbhushan Yadav, a serving officer of the Indian Navy, working for the India's Research and Analysis Wing, commonly called as RAW, India's brutal primary foreign intelligence agency, entered Pakistan with a predetermined aim on the instructions of the Government of India to assist, plan, and cause terrorism in Balochistan and the Sindh provinces and other places in the country. This much he has admitted before an independent judicial magistrate sitting in a court of competent jurisdiction with the benefit of stringent safeguards to protect him against any form of pressure or coercion when making such a confession. The Indian state-sponsored terrorism has been the order of the day. India, contrary to all international laws and norms, interferes in training and arming anti-Pakistan militia and funded them to attack East Pakistan to cause dismemberment of Pakistan, which fact in 2016 the Indian Prime Minister Narendra Modi twice admitted. The Indian National Security Advisor, Mr. Ajit Doval, makes no secret of his plans to foment and foster unrest in Pakistan through Indian spy agencies by applying what he calls a double squeeze strategy. The Indian petition at the IJ is a classic example of old adage that mouth prays to Buddha, but the heart is full of evil. May I say that I have been a victim of Indian brutalities. When I say I, my person, Indian brutalities, detained, tortured under inhuman conditions contrary to the Geneva Convention during my captivity as a prisoner of war, being a 20-year-old officer of the Pakistan Army in 1971. This is India that we sadly see all too often. Mr. President and the learned judges, even prior to the capture of Commander Yadav, it was after the speech of Mr. Ajit Doval, a huge blast wrecked Balochistan High Court at Quetta. We lost more than 70 senior, experienced lawyers. Karachi has dozens of attacks, causing multiple precious lives to be lost. Similar blasts and suicide bombers have killed numerous citizens in Pakistan. The unlawful action of India have also been proven that India has been using Afghanistan as the second front at the western border of Pakistan, as has been said by the ex-US Secretary of State Chuck Hagel in the speech in 2011 at the Oklahoma University. This has been proved by the deadly attack on the Army Public School, APS, at Peshawar, where we lost more than 140 innocent school children, some as young as 6 years old. Massacre by the inhuman attack, admittedly sponsored by India from Afghanistan on the 16th of December 2014. In fighting terrorism, we have lost more than $123 billion. Loss of sense of security, flight of capital from the country, an unbearable human cost which continue to mount. In an apparent albeit regrettable attempt to use the August Forum for grandstanding and politicking, India never notified Pakistan a dispute. through the optional protocol which could have engaged mandatory alternate dispute resolution processes for at least 2 months. But inexorably chose to ambush the court, invoking urgency. Commander Yadav planted several local residents, collaborators, conspirators, non-state actors, becoming an integral part of a network run by him to carry out the despicable terrorism and suicide bombing, target killing, kidnapping for ransom, and targeted operations to create unrest and instability in the country. His unlawful activities are directed at creating anarchy in Pakistan and particularly targeted the Pakistan-China economic corridors. Ports of Gwadar, Turbat, and Jiwani were specially identified to damage the China-Pakistan economic corridor that is bringing development to Pakistan, poorest region. In addition, he funded subversive and secessionist elements through informal and illegal money channels contrary to the laws of Pakistan and in violation to the Financial Action Task Force, FATF, principles and provisions. Commander Yadav was nominated in the police first information report for his terrorist activities prior to the judicial confession. In the existing FIR, a supplementary FIR was filed in addition on additional information given by the Commander Yadav in his judicial confession. Commander Yadav activities are not acts of an individual. Rather, these are being committed at the behest of the Indian state and the government. Commander Yadav's confession speaks of India's state policy of sponsoring terrorism in Pakistan. The act of appalling violence orchestrated by Commander Yadav and the loss of thousands of innocent lives are actual manifestation of such Indian policy. Since 1947, India has consistently pursued the policy of trying to destroy Pakistan. This has taken several forms and manifestations over the last 7 decades. India blocked river water flows flowing through Pakistan and continues to do so in violation of the Indus Water Treaty. The Indian Prime Minister, Mr. Narendra Modi, is on record to have said using water as a weapon against Pakistan. India's petition to this court seeks relief for a terrorist. For obvious reasons, he was sent by India. This has exposed the sham reality of duplicitous policy whereby India, contrary to the facts, laments, begins to being a victim of terrorism to attempt to divert the attention of the international community from its own containing policy of state-sponsored terrorism. Pakistan has treated Commander Yadav in a manner that is due to every human being. On humanitarian grounds, Pakistan has allowed Commander Yadav's mother and wife to visit him. I challenge India to quote a similar example where a person involved in espionage and terrorism was granted such an access to families on humanitarian grounds. Mr. President, honorable judges, it is the duty of Pakistan to protect its own citizens whose fundamental right to life is being violated by these vicious attacks through these designs by India. Pakistan wishes peace and a peaceful neighborhood, but does not deter us from our commitment to the duty to protect the motherland, the life, liberty, property of every person and citizen of Pakistan against all such evils by ensuring that such guilty of an offense face the law of the land. In conclusion, the people and the government of Pakistan have complete faith in this esteemed judicial institution of the United Nations. We expect this court to decide this matter in accordance with the legal principles which lead to the only one conclusion, namely, that India's claim for relief as sought must be dismissed. I thank you for your attention, and with the leave of the court, I shall now request Mr. Khawar Qureshi, QC, to take the floor and present the substantive arguments. Thank you very much.
I thank the agent of Pakistan, Mr. Anwar Khan, for his statement. I wish to assure him that I have also noted the concerns of his delegation with regard to the health condition of Judge Ad hoc Jilani. The court will provide its response to your questions in due time. In the meantime, I wish to join you on behalf of all my colleagues to wish Judge Ad hoc Jilani a prompt and complete recovery. I will now give the floor to Mr. Qureshi. You have the floor.
Mr. President, members of the court, good morning. It's my honor and privilege to appear before this court again. Having appeared before the court in the provisional measures application brought by India on the 8th of May 2017, I'm compelled to express disappointment. Yesterday was a wasted opportunity for India. This is a case in which 2 rounds of pleadings were insisted upon by India to fully rebut the law and facts. And what do we find? India fails to explain its conduct. India fails to answer serious and relevant questions. India fails to address key issues. Instead, what happens is that we have, with respect to my friend, almost a verbatim readout from his existing pleadings. There are fundamental points of principle that this case engages about the conduct of a litigant, never mind a state, seeking relief from a court, never mind the world's court. It is the brazen conduct of India which is unfortunate, and I agree with my learned friend. This is an unfortunate matter, but it's unfortunate because of the way that his client has behaved. What the court is asked to consider, for the first time in the court's history, and indeed for the first time in the context of the Vienna Convention on Consular Relations of 1963, is whether India is entitled to claim that Pakistan has breached the Vienna Convention by denying consular access to Commander Kulbhushan Jadhav, a man arrested on the 3rd of March 2016, crossing into Pakistan from Iran with intent to pursue India's deadly campaign of death and destruction in Balochistan and Sindh province. As the Attorney General has already pointed out, there is a confession by Kulbhushan Jadhav before a judicial magistrate, which has been repeated subsequently. It's important to remember that Mr. Yadav was convicted of espionage offences in April 2017 after a trial which commenced on the 21st of September 2016 and was adjourned at his request for 3 weeks to enable him to prepare with the benefit of legal advice. It's also important to remember he was convicted pursuant to Section 3 of the Official Secrets Act of 1923, which vested jurisdiction in the military courts for the offence of espionage for nearly a century, not as a result of any extension of the jurisdiction of the military courts in the aftermath of the terrible terrorist atrocities committed in 2014. And it's also important to remember that at all material times, Commander Jadhav and his family have had the right to challenge the conviction before the military court by way of judicial review, as well as to seek clemency. These are all matters that India glosses over, but that gloss will not do, because I will demonstrate to the court today that India's sham riposte, repeated reference to propaganda concoction, is nothing but a subterfuge. It's my unfortunate duty to do that, because this is a court which, mercifully, has had occasion to deal with states that generally behave decently most of the time. This is a case in which indecent behavior has to be exposed, not just because of my duty to the client and my duty to the court, because the truth must be told. India has never established that Commander Jadhav was an Indian national. India says Pakistan, by reference to the authentic false passport, authentic Indian passport in a false Muslim cover name, was satisfied that he was an Indian national, a bizarre proposition that a document tainted with illegality and blood ought to provide some semblance of legitimacy. India fails to explain why it is that he was able to use this document to enter and leave India on at least 17 occasions, and obtain visas for Dubai and Iran. India refuses to explain why it is that eminent academic commentators have observed since the 1960s that the Vienna Convention on Consular Relations of 1963 expressly left intact the customary international law position. Lest we forget, one of those academic commentators also include the former honorary legal advisor to the Indian Ministry of External Affairs. It's also highly significant, I submit, that not a single state of the 177 states that are party to the Vienna Convention on Consular Relations has embraced the invitation of this court, issued on the 20th of November 2017, to address the court on the question as to whether Article 36 provides for a customary international law exception with regards to espionage. That, I believe and submit, is yet more powerful, indeed clear, cogent and compelling evidence of the desire of states to, at the very least, maintain what I would describe as studied ambiguity on this issue, with the consequence that it simply cannot be said that the customary international law position has now crystallized to support the contention India advances. India has never explained why Article 6 of the 2008 agreement, titled On Consular Access, no less, which it drafted, does not apply. Instead, India described the agreement initially as irrelevant and not relied on. But finally, as we shall see, India did violence not just to the agreement, but to the English language to arrive at an interpretation which is nonsensical. Words mean what they say and were intended to mean when India and Pakistan adopted the 2008 agreement, not what India wants them to mean now. And I'm reminded of a character occupying a fantasy land called Wonderland. Some of you may be aware of him, Humpty Dumpty. Humpty Dumpty insisted that words meant what he said they meant. Now, we all know what happened to Humpty Dumpty. Humpty Dumpty was sitting on a flimsy wall, and when he fell, that was the end of Humpty Dumpty. And we shall see that the wall that India is sitting on is a flimsy wall of lies, and it will come crashing down when probed. India never engaged with a legitimate request for mutual legal assistance from Pakistan, sent on the 23rd of January 2017, which could have provided inculpatory or exculpatory evidence. In the face of binding UN Resolution 1373, which we mustn't forget, was adopted in the aftermath of the terrible events of 9/11, Articles 2F and G thereof oblige states, mandatory Chapter 7 UN resolution. It's not good enough for India to now contend before this court in a mealy-mouthed manner that there is no MLA treaty required, or that there should have been an MLA treaty between India and Pakistan and it wasn't in existence, or in an act of utter desperation to assert that Pakistan has failed to assist India in the past. Even if that were true, it provides absolutely no excuse. And I'm compelled to point out that India's own conduct not just in sending Mr. Jadhav, Commander Jadhav, but in the context of these very proceedings. And during the course of these proceedings is a shameless attempt to perpetuate blatant misrepresentations, not just in the pleadings, but the evidence filed before the court. It raises, I regret, and I'm compelled to say, a clear, uncontradicted basis for the court to declare India's claim inadmissible, or otherwise militates against the grant of any relief. And it's important to understand India's mindset, and the pleading is very revealing. Paragraph 77 of India's memorial states as follows: neither the charges against Commander Jadhav nor the conduct of the sending state, India, is relevant in examining the allegations of the violation of Article 36. It's a startling proposition. As we'll see, it's contrary to Articles 5A and 55 of the Vienna Convention. But if India were right, this is a charter for blatant violation of international law. A puzzling proposition from a state that professes to seek a permanent position on the Security Council. Puzzling and preposterous. But it's the core justification for India's blasé response. When asked serious questions, it invokes its mantra of propaganda, concocted, irrelevant. When it comes to this court, after we filed our counter-memorial, on the 10th of January 2018, no less, India insisted for a second round, unprecedented in a case of this nature, of pleadings to be able to fully rebut the issues of fact and law raised in our pleading. What did we get on the 17th of April 2018 by way of reply? The following proposition: India does not consider it necessary to reply in any degree of detail to the litany of false allegations being made by Pakistan. The reply, paragraph 39, an outrageous, offensive position to adopt, having asked the court for an opportunity to serve a further round of pleadings. India continues to assert, without a molecule of evidence, that Commander Jadhav, who was 47 when arrested on the 3rd of March, crossing into Pakistan from Iran, had retired from the Indian Armed Forces and was an innocent businessman. Unsurprising that they have to assert that. Kidnapped from Iran. Appalling proposition to advance, devoid of any evidence or merit, for the sole purpose of forcing him to confess to crimes he did not commit. The absurdity of this I will shortly demonstrate. And then we get to the claim for relief that India is seeking. India asks for, at the least, acquittal, release, and return. A modest claim, particularly in the light of the approach that the court has stated repeatedly in the Legrand case and the Avena case. But India doesn't have much regard for precedent, or certainly not this incarnation of India, because I must point out that I've had the honor and privilege to represent, amongst many states, India in the past. And I repeat, honor and privilege. The incarnation of India that is before this court is not one that I recognize. Even if this court were to find that the Vienna Convention was engaged, the appropriate remedy, as this court has stated repeatedly, is review and reconsideration by the Pakistani High Court. A remedy which has been available at all times since the 10th of April 2017, not just to Commander Jadhav, but his family. India resists claiming this remedy because it's got an all-or-nothing strategy. And I remember what I said to this court on the 15th of May 2017, that these are proceedings launched for political theatre, making a claim for relief that's unsustainable, and they should be dismissed. Now, the court has before it my written submissions and a copy of this electronic presentation. There are 9 aspects to this presentation which I shall go through. First, I shall deal with the context. My learned friend, Mr. Salve, says there's no credible evidence against Mr. Jadhav. Well, I will demonstrate how not only is there credible evidence from the hand of India itself, but independent analysis, evaluation by highly respected individuals who sadly have had the misfortune to be called traitors. corroborates the confession. Far from India's conduct being irrelevant, the bold proposition, the blanket immunity from law and morality that India seeks for itself, its conduct is highly relevant. India shirked from even approaching the gateway to engage the Vienna Convention on Consular Relations. It never established nationality, and we can see why. By clothing an individual with a false passport, a false Muslim name by way of cover, in an authentic, giving him an authentic passport, making sure that he was embedded in its system. How can India possibly provide us with a copy of his actual passport? It shows the lie to India's position even more dramatically. Fourth point, customary international law, state practice did not provide for consular access prior to the Vienna Convention on Consular Relations, and the Vienna Convention expressly preserved the position of customary international law in 1963. Even if the Vienna Convention was engaged, consular access to a prima facie case of espionage suspect would violate Articles 5A and 55. The principle of upholding international law, not violating it, and not interfering in the internal affairs of the state. Much as it might wish to, point 6, India cannot wish away Article 6 of the 2008 agreement. The claim for at least acquittal, release and return is outlandish, and effective review has always been available before the Pakistani courts. Much as India might wish to insult the institutions of Pakistan, they have been robust and continue to be robust to uphold the rule of law. Most recently on the 18th of October 2018, when the Peshawar High Court had no hesitation in overturning 70 plus death sentences and convictions for terrorist offences. And last, concluding remarks. The fundamental flaw in India's position is that neither the nature of the charges nor the conduct of the sending state is relevant. And as I point out, that's an absurd proposition. One only has to see it on the screen, to read it, to process the words, to see how nonsensical it is. But well, let's look at Commander Jadhav's conduct. And his admission included the following. The references to my written submissions, page 6-7. He was a serving officer of the Indian Navy, due for retirement in 2022. He was 47 at the time that he was arrested, with a cover name of Hussein Mubarak Patel, which was used for intelligence operations on behalf of RAO, India's principal foreign intelligence agency. RAO began to sharpen the focus on undermining Balochistan around 2014, when the new government came to power in India. Commander Jadhav was apprehended soon after having crossed the border into Pakistan from near Saravan. His intention was to meet his assets, the instruments of terror, the terrorists used by India. He was travelling with his RAO handler, Rakesh, up to the border. He was carrying the cover name Indian passport, so that if stopped and checked, he could demonstrate he held a valid visa to be in Iran. India resists, according to Mr. Salve, the temptation to answer the following questions. When did he retire and why? Well before retirement age. What evidence is there that he's retired? I'm very happy to ask my learned friend for an explanation as to why, if Commander Jadhav had retired, on the 29th of February 2016, Commander Jadhav's account received 90,605 rupees by way of pay, not pension, pay. I'm quite happy to share this with my learned friend. I'm quite happy for him to see these, because India, unfortunately, is too reticent to share with this court the evidence which would demonstrate its own moral turpitude. Why was he in possession of an authentic Indian passport with a cover name? Yet again, what is India bashful about? We provided India with a copy of a detailed explanation provided by Commander Jadhav in a 10-minute video yesterday. It's not in the public domain. It's not been leaked to anybody. India's answer to try and block it from being presented before this court was, no explanation has been provided as to the need for production of this evidence. Really? It answers the question why he was in possession of an authentic Indian passport. If this is allowed to be exhibited, India will be seriously prejudiced. Yes, absolutely. Because the world will see why you gave him the passport, who gave it to him, when they gave it to him. And he will explain, in his own words, that so far as he was concerned, this is an elementary tool of spycraft. And it's a pity that India, at every available opportunity, seeks to block any access to the truth. If he was forcibly taken from his cover business base, how did he end up making the 9-hour journey to Pakistan? In the boot of a car? And what steps did India take to seek an investigation within Iran as to the alleged kidnap? The answer, I hope, will be provided at some stage. Unless anybody suggests that Pakistan's alone in asking these questions, there are 3 highly credible, independent Indian journalists who've carried out their own investigations from April 2017 onwards. Each and every one of them has been subjected to scurrilous abuse, from showing anti-national stand, to being a traitor, to being a swine, to advancing concoction, and most recently, to be the subject of a criminal complaint for sedition. So much for the world's largest democracy and freedom of press. The first gentleman, Karan Thapar, is the son of the former Indian Army Chief of Staff. Hardly a rebel renegade, one would have thought. Former CNN correspondent. And what does his article say? It's in the Judges Bundle at tab 26. The case offers more questions than answers, the case of Commander Jadhav. And he asked the Ministry of External Affairs about the passport. They said they needed to access Commander Jadhav to check why he had the Muslim cover name passport. That's my language, and the one in his own name. And he asked them, not unnaturally, why not check the records attached to the passport numbers? Surely they would tell a story. It's not a story that India wants the world to read or hear about. So it just uses the phrase concoction, propaganda, litany of lies. Well, these lies are being exposed here and now. Praveen Swami, former diplomatic editor of the Daily Telegraph of London, no less. His journalism is the epitome of journalism. These individuals represent the beating heart of the India that I have respect and admiration for, that I work with. They are fearless, prepared to expose the truth and stand up for pluralism and secularism and democracy. And what does Praveen Swami identify with reference to intelligence officers' interviews, with reference to interviews with people who served with Commander Jadhav? That Rao was building up a covert action program to target Pakistan from 2013 onwards, as masterminded from May 2014 by Ajit Doval. We'll see a picture of him shortly. I'm sure he doesn't want the world to see it, but they will. The National Security Advisor to the Prime Minister of India. That Commander Jadhav established a cover business in Chabahar, which did little business. Very similar to what Commander Jadhav was saying.
Mr. Qureshi, I'm sorry to interrupt you, but could you kindly speak a bit slower for the interpreters?
Of course.
Thank you.
The Muslim cover name passport gives an address, which is property owned by Commander Jadhav's mother. According to a Rao official, this makes it impossible for India to deny he is who he says he is, which apparently is a basic element of tradecraft. No doubt angered by this exposure, the very same Rao official went on to say it's criminally irresponsible for a spy's cover identity to be so closely linked to his real life. It seems, unfortunately, that Commander Jadhav was displaying the arrogance which is reflected in the conduct of India in these proceedings. What was the answer of India? To describe the article as concocted and mischievous. And what was the response of the public of India, who unfortunately had been whipped up into a fury, as no doubt they are being right now as I'm speaking, to encourage the murder of Praveen Swami as a traitor. Chandan Nandi, the former senior assistant editor of the Times of India Group, one of only 2 newspapers of record of India, Judges Bundle, tab 27. He was forced to retract this article the very next day. There's no suggestion that it was inaccurate. The suggestion in the public domain is that he was put under intense pressure and is the subject of a complaint for criminal sedition. And what does he say? The clearest evidence that Jadhav operated for the Rao came to the fore only after his cover as a businessman who would frequent Iran, especially Chabahar, was blown and he was captured by Pakistan, following which a former RAW chief, besides at least 2 other senior officers, called his Mumbai parents to advise them not to speak about their son's case to anybody. The other evidence, the evidence that India doesn't want to engage with, the evidence which is damning as to India's illegality, was the second passport with the name Hussein Mubarak Patel that he carried, which shows that it was originally issued in 2003 and was renewed in 2014, while one passport is in his name, and mercifully, whilst we've been asking since May 2017 for India to provide a copy of his actual passport, the way that normally nationality is established, it's taken a journalist to tell us what his actual passport is. The second one raises more questions, especially the date of its issue, and why he signed it as Hussein Mubarak Patel to enter into a property deal with his mother in Mumbai, where he lived, with his wife, parents and children, before he was nabbed, they say, we say arrested, by the Pakistani intelligence services. Now, Dr. Mittal is sitting here next to me, and Dr. Mittal had no problem respectfully submitting to the court that India believed Commander Jadhav had been kidnapped from Iran. Memorial, 13th of September 2017, paragraph 41. Reply insisted upon, 17th of April 2018, paragraph 31E. Where's the belief? India hosted the president of Iran, no less, on the 19th of February 2018, in between India's rather bare memorial and even barer reply. Perhaps Dr. Mittal will explain to this court eventually why he didn't ask the president of Iran, or the Indian government didn't ask the president of Iran, the questions that journalists were positing to Dr. Mittal. The first question, this is an official Ministry of External Affairs release on the 19th of February, Dr. Mittal deflected, I'm being polite, questions. Did we raise the issue of Jadhav's abduction from Iran? The issue did not figure in the discussion. Is there any reason why the Jadhav issue did not come up? Why we did not want to bring it up in our discussion? It's not a bilateral matter within Iran in any case. Was it our decision that we did not want to include Kulbhushan Jadhav in one of the areas during the visit? Or we wanted it, but Iran didn't want it? The answer would be no. And as I mentioned, this is not a bilateral issue in any way between India and Iran. Please, Dr. Mittal, tomorrow explain how you can respectfully believe that he was kidnapped. Then we come to the crux of the matter. The reason dead for creating people like Kulbhushan Jadhav. And it's embodied in this gentleman, India's so-called super spy, who outlined how he wanted to tackle Pakistan in a disgraceful show of bravado at a university, no less, Sastra University. Judge's Bundle, tab 25, page 2, 9th paragraph. What does he say? In a speech that was quoted on the 30th of September 2016 in the Indian Express, a speech he'd given in February 2014, prior to the election of this present incumbent government. A speech which it's not been suggested as inaccurate. Ordinarily, as all of us understand, if somebody is misquoted in a newspaper, generally they make an effort to try and obtain a retraction or an apology, generally. If they don't, then one's left with the impression that what's in the paper is true. Unfortunate. But in this case, India has had access to this since December 2017. It's not said this is not accurate. So the court proceeds on the basis it is accurate, unless Mr. Doval wants to come to court tomorrow and say otherwise. Pakistan's vulnerability is many times higher than that of India, he says. Once they know India has shifted its gear from the defensive mode to defensive offense, they will find that it is unaffordable for them. You can do one Mumbai, you may lose Balochistan. There is no nuclear war involved and there are no troop engagement. If you know the tricks, we know the tricks better than you. A shameful, disgraceful way of putting a position of a state forward without any apology. And yet, despite all of this, India has the audacity to describe the trial of Commander Jadhav as farcical. India has the audacity to criticize the death sentence, which was imposed after a trial lasting nearly 6 months with 4 stages, giving Commander Jadhav 3 weeks to prepare, at his request, an adjournment with a legally qualified defending officer. I say audacity because very recently, on the 30th of January 2019, the Indian Prime Minister, no less, reflected a lynch mob mentality, I'm sorry to say, where he extolled the virtue of rapists being hanged within 3 days, 11 days, and 1 month. And then the fact-check correction suggested that what he was saying was being sentenced to death within 3 days, 11 days, 1 month. The references are in the written submissions. So we move on to the next phase, India's conduct, abusive process. India has deployed this process for political theatre, for point scoring, seeking, in the words of my friend Mr. Salve, when he was trying to knock out the Marshall Islands case, remedies and relief far beyond those that would flow. Why did India come to this court on the 8th of May, demanding an order for provisional measures without a hearing, insisting that Commander Jadhav could be executed any day, insisting that his death was imminent? Why, when proper examination takes place, is this case as far removed from Legand, where somebody was executed in the face of this court's provisional measures order, or Avena, where people continue to be executed in the face of provisional measures orders? Why is this case as far removed as can be from the invocation of provisional measures, never mind provisional measures without a hearing? And what was India's objective? Was it really, if one seeks to descend into the febrile or perhaps demented imagination that might be behind this, was India really expecting that Pakistan would execute Commander Jadhav in the face of this court's order? India doesn't know Pakistan. Pakistan is a state that has provided one of the largest contingents for peacekeeping for the United Nations, whose soldiers have lost their lives in pursuit of international peace and security. And India seriously expected, in that context, I'm imagining what a demented imagination might be wishing in the face of a provisional measures order, that Pakistan would violate that order? On the contrary, not only was the order obeyed and respected, as Pakistan has repeatedly pointed out, but Commander Jadhav has been visited by his mother and his wife on Christmas Day, the birthday of Mr. Jinnah in 2017. India couldn't resist spinning that either. So, India, I'm sorry to say, has demonstrated a lack of good faith throughout these proceedings. And I'm going to identify 3 abusive rights which India has manifested, because good faith is unquestionably a part of international law. And if my friend wants to tell me that Sir Harsh Lauterpact isn't an authority for a proposition of international law, then I welcome him to do so. The 3 abuses are as follows. India needs to explain how Commander Jadhav was an Indian national, provide evidence of the same. They won't provide his actual passport in his real name. To suggest that a false cover name authentic passport is valid evidence of Indian nationality is at best perverse. However, India goes one step further, and India is adamant that Commander Jadhav has not committed a criminal offence, and he is not going to be investigated. Indian Passport Act 1967 makes possession or use of a document in a false name a criminal offence, punishable by imprisonment, unless the state has given immunity. So it may be that the reason why Commander Jadhav has not committed a criminal offence is because, according to the statute, he's been given immunity. It gets murkier and murkier if India tries to answer, and no surprise that it doesn't wish to. By failing to engage with the mutual legal assistance request of 23rd of January, India did anything other than provide the greatest measure of assistance in connection with criminal investigations or criminal proceedings relating to the financing or supporting of terrorist acts, including assistance in obtaining evidence necessary for proceedings. And why do I say that? Because most mutual legal assistance requests are not based upon treaties, and certainly not if they're invoking a mandatory UN resolution, such as this. To say this is propaganda is, with respect, risible. To say that India wasn't provided with enough information is equally far-fetched. The MLA request identified Commander Jadav's activities, his own confession no less, the first information report, the criminal provisions of Pakistan's law that were engaged, and identified the evidence that was required. Bank account records, information relating to individuals that it named, including an Inspector Bali, who, when India watches the video, which I assume they have, is the gentleman who gave the passport to Commander Jadav. What does India say? It's propaganda. What else does India say? Well, we made 18 requests for mutual legal assistance, which then jumps a few paragraphs later to 40, unable to contain their enthusiasm for exaggeration, that haven't been answered by Pakistan. Is that justification? The third point, failing to provide any form of explanation how it is that Commander Jadav was able to travel frequently to and from India, using an authentic Indian passport bearing a false identity in a Muslim name. It simply cannot be legitimate for a state to issue travel documents in false identities, which are otherwise authentic and facilitate travel, as well as provide cover for illegal acts. I say that, and if authority is needed for that proposition, one turns to the very same Security Council Resolution 1373. Article 2G demands controls on the issuance of travel documents, not liberally providing them to enable cover for illegal, criminal activities, destructive activities, including espionage. Requires that states accelerate exchange of information, especially regarding terrorist persons' movements, forged or falsified travel documents. And that's what India was being asked for on the 23rd of January 2017, when a copy of the passport, assuming India didn't know what the passport said, was provided to India. And India ridiculously put the documents back, proverbially in the post, of course, the diplomatic bag, sent them back to Pakistan. I say ridiculously, as if somehow wishing to push this issue away, metaphorically, legally, physically, morally, but they couldn't because it's here before this court today. And it's a simple proposition, and again I challenge my learned friend to explain to me why Judge Schwebel, no less, isn't authority, never mind Sir Gerald Fitzmaurice, for the proposition that an unlawful act cannot serve as the basis for an action in law. Because if he's going to say Sir Hersch Lauterpacht, Judge Schwebel, and Sir Gerald Fitzmaurice are not authorities, then I'm afraid all of my studies of public international law have gone to waste. The failure to engage with the mutual legal assistance requests is only for one reason, due to the lack of clean hands on India's part. The failure to rebut the clear and necessary inferences that India provided an authentic Indian passport to Commander Jadav in a false Muslim cover name is compelling evidence that India's hands are sullied, and that its claim to seek consular access is founded upon a bed of moral turpitude. I'm not making these submissions lightly. I make them with a heavy heart, but I'm compelled to make them because it's the truth. These observations are based not just upon the unchallenged evidence of an expert, but the court has been given an insight into the investigative efforts of three separate Indian, highly credible, highly respected journalists supporting these propositions. To suggest this is a concoction, to suggest this is propaganda, is utterly absurd. And India knows that. India's note verbal, dated 11th of December 2017, stated, it's not as far off into the distance as the typo would suggest, One wonders what will be here in the year 2011-7. It's 2017, of course. What did India say? That Pakistan's asking repeatedly for an explanation in respect of a purported document that looks like a passport. It's a document. Whether it purports to be a passport or not is another matter. It's not a purported document, it's a document, and which on the allegations made by Pakistan is clearly a forgery. Well, we never said it was a forgery, but thank you for saying that for the first time. And then perhaps you'll explain why it's a forgery. Pakistan has raised questions on the provenance of the document that looks like a passport, and it smells like a passport, and it feels like a passport, and surprise, surprise, it is a passport, and seeks explanations from India in relation to the same document. Yes, you understood perfectly well, India, what Pakistan was asking for. But what did you say? When we asked on the 19th of January 2018 how you had described it as clearly a forgery, because by then you had received our counter memorial, Annex 141 thereof, tab 3 of the judge's bundle, was a report produced by an independent expert, Mr. David Westgate. We asked you, having read, one assumes, the counter memorial by then, having had it for nearly a month, how did you disagree with his conclusions, which included that the passport was a genuine and authentic Indian travel document and not a counterfeit? How could you rebut his understanding? Because he said, from my knowledge and understanding of the airport immigration system in India, the immigration counters are connected to a central database, and any irregularities in the authenticity of a passport would ordinarily be flagged up on such a database. And then what did he say in his conclusions? Based upon my observations and my experience in examination of the passport, I am satisfied that it is an authentic Indian passport, which I believe must have emanated from the Indian authorities. And how did he sign off? I fully understand my duties to the courts when giving an expert's report. And what was India's answer? 3 months later, the questions were aimed at propagating falsehood and propaganda by Pakistan in the matter. This is a passport, I must remind the court, that had been used on at least 17 occasions by Commander Jadhav to come in and out of India. And what did India do? Not content with describing Pakistan's position as aimed at propagating falsehood and propaganda, they added insult to injury. The injury that Commander Jadhav has caused countless civilians in Pakistan. The destruction, the trail of destruction and devastation that he's left behind. The guiding hand of which is Mr. Ajit Doval, insultingly describing Mr. Westgate as a purported expert. There's that word purported again. The word that people use when they don't want to believe the truth. Well, what's his expertise? The court has his report in front of it. But I'll just read it out for the benefit of India in case my learned friend never read it. Paragraph 3. In the course of my work, I've examined many thousands of travel documents. Specifically, I have experience of Indian travel documents due to my 3 years' experience in the region and the follow-up work I conducted while serving at the NDFU, National Document Fraud Unit of the United Kingdom, which is the Centre of Knowledge and Information for the UK Home Office for all travel documents. Paragraph 5. I'm presently engaged in forensic analysis and business support for a major international company that produces passports and identity cards. Paragraph 7. On 7th of November 2017, I conducted a physical examination of the passport in London, United Kingdom. The document was handed to me. During the course of my investigation, I used a long-wave UV light source and magnification, not throwing it up in the air with a coin at the same time, heads it's authentic, tails it's fake. Paragraph 9, details of the passport. The document that was presented to me purports to be an Indian passport of the L series, which I'm very familiar. He says purports because he hasn't examined it yet. That's the chronology of events. Although I held no comparison material, from my knowledge, expertise and familiarity with these documents, I can state that it is a genuine document and not a counterfeit. The document contains various security elements which together make the document what it is. I noted the presence of a high-quality cylinder mold watermarks throughout the document, random UV fluorescent fibers and high-quality print. I should point out that in the counter memorial, the court will find that the ICAO guideline 9303, 7th edition, 2015, identifies the standard pursuant to which travel documents ought to be issued by states if they want their nationals and those who are masquerading as their nationals for legitimate and illegitimate purposes to travel. And these are the characteristics from there. The main portrait in the document is inkjet printed, and there was no evidence to support that this image has been manipulated. There is an additional ghost image which is made up of personal data in a wave pattern, which adds further confirmation to the authenticity of the image and data. The laminate is a security print on the inside, which I found to be clear and undamaged. I find no evidence that the image is not original to the document. And what did he say? He'd served as part of the UK Home Office in Immigration Intelligence for more than 27 years. The UK Home Office and Intelligence. He's been a member of the Heathrow Terminal 4 forgery team for 11 years, and then served on attachment to the Foreign and Commonwealth Office as Immigration Airline Liaison Officer based in New Delhi. Yes, New Delhi. Serving the whole of northern India and Nepal, advising airlines and border security control officials on forgery and fraud in travel documents. And then what did he do? He left the Home Office in 2017, but he served as Chief Immigration Officer at the National Document Fraud Unit. The NDFU is the Centre of Knowledge and Information for Travel Documents. He's provided evidence in both Crown and Magistrates' Courts representing the Home Office in cases involving document fraud. To describe him as a purported expert 4 months after having read his report is galling. To describe him as a purported expert after he'd spent 3 years in India as Immigration Intelligence Liaison Manager, where his CV also tells us he'd worked closely with Indian intelligence officers, police, UK security services, and the visa sections across the whole of North India and Nepal, advising Indian and Nepal border control on documentation and security. To describe, nevertheless, the position in the light of this report as propaganda, as farcical, as mischievous, as part of a litany of false allegations which India will not respond to, is disgraceful. And we say it's reached the level of disgrace for this court, for the first time ever, to conclude that India is guilty of egregious illegal conduct in providing Commander Jadhav with an authentic passport and false identity and dispatching him to carry out acts of espionage and terrorism in Pakistan in contravention of the Charter of the United Nations. The Attorney General gave the court an insight. And of course, it's all too often the case that there are complaints and counter-complaints, allegations and counter-allegations. Here, perhaps for the first time, we have a court which is presented with clear, compelling, uncontradicted evidence of the turpitude of a state abusing the facility of provision of a passport to provide one of its agents of destruction and terror with a facility to be able to wreak havoc in Pakistan. Havoc that, thanks to the sterling work of the Pakistani security services, he was prevented from continuing. Havoc which must have consequences, not just for India, but for Commander Jadhav. The idea that he can be immune in the way that India suggests it is immune for its actions is obnoxious, I'm sorry to say. And we say, as a consequence of all the evidence that's before the court, the burden of proof shifted to India in December 2017. After all, India asked for a further round of pleadings to fully rebut the facts in the law. And what did it do? It didn't. The burden of proof shifted to explain the passport issue and explain India's conduct. It just wasn't acceptable to avoid doing that. The second aspect of India's conduct, which is unsavory and which I'm forced to bring before this court, is the report of the military experts and India's doctoring of it. India doesn't like the truth, I'm sorry to say, and I'm not going to varnish it, because the truth has to be heard. Yesterday, we heard Mr. Salve's mealy-mouthed explanation for doctoring the experts' report, and yesterday, the experts, by way of a supplemental report, sought to make it absolutely clear what they intended in their report, lest anybody who doesn't understand the English language in the way that it's meant to be understood was under a false impression. And India tried to block that. It wasn't an unabashed attempt to lead further evidence. It was to address misrepresentations. But of course, that's not what India wanted. What was impermissible was not allowing the experts to come before the court and say, unlike Humpty Dumpty, we used plain English. We didn't give India a license to add or delete words. India didn't want you to hear that, honourable members of this court. But I'm telling you now. The military experts, the distortions, the shocking distortions. The first one is the typographical error that my learned friend says entered into paragraph 154. But he couldn't stop himself, because yesterday, paragraph 222 of the transcript, he said, in paragraph 3D of the report, the experts state their conclusion that manifest failings can be remedied by judicial review. India relies on this statement as an acknowledgement that there are manifest failings. I don't see how, given that they use the word potential. But there you have it. We obviously have been using different languages and different dictionaries in different parts of the world. It does so in paragraph 19 of the reply. Pakistan does not suggest there is any misquotation in this paragraph. I say he couldn't help himself because if he'd bothered to look at our rejoinder, page 4, part 2, paragraphs 24 to 26, we made it clear we were taking issue with paragraph 19 and paragraph 154D. So, sadly, with respect to my friend, we did. But this is yet another example of a catch me if you can type attitude towards legal proceedings. Well, we have caught you. Deletions and additions of words is the order of the day. Deleting the word often was the second distortion. And then, wanting to pretend that the experts, as objective, independent bystanders, with their expertise and credibility, were not trying to help the court by referring to the fact that courts which tried terrorism offences both in India and Pakistan had both been subject to general criticisms. They gloss over the reference to India and Pakistan and create the irresistible impression that the experts were only referring to India. Now, if one mistake had been made, one could understand its perhaps carelessness, incompetence. If two, troubling. Three, deliberate. Even worse. As the court knows, we have repeatedly written to India to ask India to correct. In June of last year, before we were finalising our rejoinder, we asked India to correct to check the contents of the rejoinder, and we were brushed aside when the rejoinder was filed. Subsequent to that, India could have corrected. We were brushed aside, told, take it up with the court. We took it up with the court on the 19th of January of this year. And what happened? India maintained its position. Then I, as a matter of professional courtesy, drew it to the attention of my friend Mr. Salve on the 7th of February, because some of us still believe in professional courtesy, some of us believe in professionalism. I'm sorry to say I never received a reply from Mr. Salve. I pointed out 14th of February would be an opportune date to provide me with a response so that we could take stock. So to say that the experts have been deployed before this court late, as India has done in its letter of yesterday, fails to prepare the court and provide the court with a full picture. Unsurprisingly, we were trying to give India every single opportunity to correct, to clarify, to apologize. And it's only at the last moment that we wanted the court to be made aware exactly of what the experts had said, and that is why the experts were keen to ensure that there was no misunderstanding and to file a supplemental report. Each and every opportunity India was given, arrogantly, it dismissed. Well, you can't dismiss the truth. It's here now. And each and every one of those opportunities just adds to the edifice of deliberate conduct. Because if you're given 4 opportunities to correct the position and you don't, it's difficult to conclude other than you're being cavalier, you're being arrogant, but you're also being very insulting. And that won't work. There may be some courts in this world where it's possible to get away with a license of this nature, but this court is not a court where any litigant, let alone a state, or any advocate can be allowed to play fast and loose with the truth. And it's important for this court, even if this is the first time ever in the court's history, to identify what the red lines are for conduct. Sadly, we're living in a world in which the rule of law is coming under increasing threat. And it's important for this court, as it has done historically throughout its existence, to inform the world where the lines are and not to allow them to be erased or blurred by states that believe that alternative facts, fiction, fantasy, fallacy, are the order of the day. And then we move on to the second category of misleading. It wasn't enough to doctor the military experts' report. India had to then try and disavow its own handiwork. The 2008 agreement on consular access. India's reply said, this has no bearing on the present dispute. I remind myself, the title was Agreement on Consular Access. But now it says it does have meaning. It does supplement and amplify the understanding of the parties vis-à-vis the Vienna Convention in some ways, but conveniently not in this case. Why? And this is where yet further distortion comes in, because what India does is totally misreads deliberately the terms of the convention, the bilateral agreement. Pakistan's not relying on Article 4 or 5, it's referring to standalone provision, Article 6, which I shall take the court to. What does Article 6 say? I'll explain that full stops have a meaning, commas have a meaning. This is not a lesson in punctuation, this is a lesson in accuracy. Article 6 says the following: in the case of arrest, detention or sentence made on political or security grounds, each side may examine the case on its merits. That's pretty clear language. What does India do? In its memorial, paragraph 92. The 2008 agreement was entered into for furthering the objective of humane treatment of nationals of either country, arrested, detained or imprisoned in the other country, and by which the two signatory states, India and Pakistan, agreed to certain measures. No qualms with that. These included the release and repatriation of persons within 1 month of confirmation of their national status and completion of sentence. No qualms with that. The agreement recognized that in case of arrest, detention, or sentence made on political or security grounds, each side may examine the case on its merits. Absolutely right. That's Article 6. But then what happens? The text. The case of arrest, mischievous comma, and the addition of the words "and that," what I describe politely on its merits. India's creative addition. That's Article 6. Others may say, but then what happens? Deceit. In special cases, which call for or require compassion and humanitarian considerations, what I describe, each side may exercise its discretion, subject to the laws and regulations, to allow early release and repatriation of prisoners. India does not seek early release or repatriation of Jadid, as contemplated by the 2008 agreement. What utter nonsense. By simply, I say simply, adding a comma and the words "and that." I no doubt Mr. Salve eventually, when pushed, will tell us that was yet another typo. It's a simple fact that the 2008 agreement was negotiated over a period of 3 years. Indeed, it expressly sought to replace an earlier agreement, operating since 1982, no less. Article 3 of that agreement, which the Article 6 sought to replace, was much more detailed. Each government shall give consular access on a reciprocal basis to nationals of one country under arrest, detention or imprisonment in the other country, provided they're not apprehended for political or security reasons offences. Requests for such access and the terms thereof shall be considered on the merits of each case by the government arresting the person or holding the détenus prisoners, and the decision on such request shall be conveyed to the other government within 4 weeks from the date of receipt of the request. It's exactly the same language, consideration on the merits, political security reasons, offences. Somehow, unfortunately, when it comes to this case, India's answer is, but Pakistan never referred to it. Well, you did, as I'll show shortly. And when did you refer to the Vienna Convention on Consular Relations, as my little friend reminded us yesterday, in your regular missives about consular access? Did you invoke the Vienna Convention on Consular Relations? Was it necessary? You're saying it's an agreement between the parties. So was it necessary to refer to it? Was it equally necessary to refer to this 2008 agreement? And we'll come to the 2000 agreement subsequently. And the third category of misleading, which I have to say I am much more disappointed about, because I would have wanted Mr. J.P. Singh to be available for this court. He submitted what he described as a 7-page report dated 26 December in the aftermath of the visit to Commander Jadhav of his wife and mother. Now, if it's being suggested that Commander Jadhav's visit was evidence of impropriety on the part of Pakistan, we're very happy to share the entire video, unedited, of the interaction between Commander Jadhav and his wife, with J.P. Singh looking on to ensure that matters were dealt with properly. And the video will show that Commander Jadhav's mother commented on his excellent health. We referred to the report as being materially inaccurate, and we asked Mr. Singh be tendered for cross-examination. India refused and said we should take it up with the court. We asked, by note verbal, 5th of June, for India to check the accuracy of the contents of the reply. And again, we were told, in essence, as is characteristic of India, this is inappropriate, irrelevant, by letter dated 27th of June 2018. So much for wanting to help. And sadly, even in this day and age, sadly, even a handshake seems to be misunderstood. On one side, it's a sign of respect. On the other side, it's a sign of shame, decorum. That's all we're asking for. So we asked the court on the 18th of January for Mr. Singh to be available for cross-examination. And the reply was a model of evasion. Well, he didn't give a witness statement. He gave a report. And then what happened? Oh, by the way, he's corrected his report. The date wasn't the 26th of December. It was the 5th of January. And this is the marvel that we were presented with, purportedly dated 8th of August 2018, provided by way of attachment to a letter dated 23rd of January from Dr. Mittal. Why, one asks, when we were raising this with you in June of 2018, when you had notice from us that there may be issues about inaccuracy, why is it that Mr. Singh is writing this letter in August 2018? Was it the monsoon heat that got to him, that made him remember the date of the letter? Because what he says is, I know it's dated the 26th of December, illegibility is not quite right, for whatever reason. Happy to see the original, but you should read it as 5th of January 2018, sent to Dr. Mittal. Now, I'm sorry that he's not here, because this letter can be easily demonstrated to be a concoction, to use India's words, a manufactured. Melodrama is added to this letter by the use of the word secret at the top right-hand side. Bizarre that a letter that is supposed to be secret finds its way as an annex to a reply to a plea to a case before the International Court, and is now being seen by the world at large. We will see at the bottom that J.P. Singh arrived in Delhi at 3:45. It's dated 26th of December 2017. It's 7 pages. And he says, at the bottom, he signed it in New Delhi. Well, actually, he didn't. He says himself, he didn't. So, the date's wrong. The date of the letter, when he signed it, is wrong. Where he signed it is wrong, because on the 28th of December, he went back to Pakistan, where he's the Deputy High Commissioner. And what else was there in this letter that is objectionable? It's written to Dr. Mittal, and I'm reminded that he's sitting next to me. Of course, he's the agent for India. If anybody knows about Indian culture, it's Dr. Mittal. And what does he say to him? While the government of Pakistan had assured a security check with full dignity, the Pakistani security official removed all the ornaments and bangles, including Mangal Sutra and Bindi, which are of immense religious sensitivity in Indian society and a symbol of a married woman. Did Dr. Mittal really need to be told that? Did he really need to be told that? Please. You may fool yourselves, but you don't fool the rest of the world. And then what does he say? The appearance of Mr. Kulbhushan Jadhav. While I could not hear the conversation of Jadhav and family members because of two glass partitions, the physical appearance, gestures and body language indicated the following. His face was looking...
Mr. Qureshi, the interpreters are having a lot of difficulty to follow you.
I apologize.
So if you can please slow down for their sake.
I can only apologize. I'm conscious and anxious to ensure that the material is... We have a time limit. I want to stick to the time limit. I'm not one for elongating time limits, so I apologize for going through this at my normal canter speed. I shall refrain. I'll move into walking trot, shall I? Yadav's face was looking puffy and swollen. He was very hyperactive. Seemed as if he was not in his senses, was under the influence of something. Shorthand. He'd been tortured. He'd been drugged. This is an independent medical expert, no less. Dr. Nilsen, a German national, not a Pakistani national, based in Dubai at the Saudi-German hospital, a consultant who produced a 14-page medical report, independent medical examination on the 22nd of December, concluding that Commander Jadhav was in excellent healthy condition. 3 days later, we're told he was looking puffy and swollen. He's not in his senses. Now, I have to make the following observation. It means this, that up until the doctor saw him, Commander Jadhav was healthy, and in the interim, he was tortured and sedated. Now, I don't mean this in jest, but was that necessary for him to see his mother and his wife? Is that the reason? It just illustrates the absurdity of the proposition. And then paragraph 15. KJ's video released by Pakistan side after the meeting. The court hasn't seen this, but I may as well tell everybody what the video says. It's Commander Jadhav, untutored, unprompted, exasperated at the fact that JP Singh was shouting at his mother and wife. This video was released on the 4th of January 2018, not a few days after the meeting. So you see the entire narrative of JP Singh breaks down, because it wasn't a few days after. So much for truth and accuracy. I do wish JP Singh well in his future career as a fantasy fiction writer. But the next time he wants to produce a document which is going to be put before court, I hope he'll make himself available for cross-examination. Third point, at no material time, even now, has India furnished any evidence that Commander Jadhav is an Indian national, despite repeated requests. The gateway point that I mentioned at the outset. Is this a convenient moment?
Yes. It's a moment for a break, and therefore the court will observe a 15-minute break. The meeting is adjourned. For a break, and therefore the court will observe a 15-minute break. The meeting is adjourned. It's a moment for a break, and therefore the court will observe a 15-minute break. The meeting is adjourned.